Hello, this is Gwungmijana Legal Discourse for Criminal Law 2 series. Welcome, first time viewers or old viewers, you are all welcome. But if you have not done the needful, which is subscribing, please do so. That's what keep it going. Thank you. In today's tutorial, I'll be discussing offenses against property, specifically stealing. So the eighth topic is offenses against property. Then our focus under that is stealing. Stealing is one of the offenses against property. So at the end of this video or this tutorial on this topic, you should be able to know what is stealing under the criminal code, the elements of stealing and their intricacies, what it entails, and the punishments for stealing. That should be your expectation for this tutorial by the time this tutorial will end with the last video. Now let's begin. By way of introduction, stealing is one of the offenses against property. Recall that under the classification of offenses is also classified into according to the objects committed against. Classification of offenses according to the object of the offense. Classification of offenses according to the objects of the offense. So offenses are classified also according to the object committed against, or based on the object. That is the object that the offense is committed against. And under that we have offenses against persons and offenses against property. Our focus is on offenses against property and specifically stealing. So stealing is one of the offenses against property because it is committed against a person's property, the object of the offense. The receiver of the action of stealing is the property, is property that belongs to a particular person. So that's by way of introduction. Now, what is stealing? What is stealing? Well, our principal legislation on this course, which is the criminal code, did not leave us alone to wander in the wilderness looking for the definition of stealing. The definition had been provided for us under the criminal code. Therefore, we shall not wander or beat about the bush looking for the definition. We shall not rigmarole, but we shall rely on the definition provided under the criminal code. So stealing is defined in section 383 sub 1 of the criminal code, provides the definition of stealing. And let's hear from the horse's mouth. Let's see what the section provides, or how the section defines stealing. Let's see the section. Section 383 sub 1 of the criminal code. It provides as follows. A person who fraudulently takes anything capable of being stolen or fraudulently converts to his own use or to the use of another person anything capable of being stolen is said to steal that thing. So a person, any person who takes fraudulently, if you take fraudulently anything that is capable of being stolen, or if you convert fraudulently to your own use or to the use of another person anything capable of being stolen, then you can be said to steal that thing. So a person can be said to steal a thing once it takes fraudulently. Underline the word fraudulently. That is the operative word. The taking must be fraudulent. You must take in a fraudulent manner. Or the conversion must be fraudulent. It must be converted fraudulently. And as we shall proceed, we shall see when a person can be said to take a thing fraudulently or convert a thing fraudulently. But the important point to note is that the thing must be taken fraudulently. When you take something fraudulently or you convert something fraudulently to your use or to the use of another person, then you can be said to steal that thing. Stealing can be said to have taken a place. That is the definition of stealing. So simply put, stealing is fraudulent taking or conversion. Fraudulent taking or conversion. So once you take something fraudulently, that's stealing, or you convert something to your own use or to the use of another fraudulently, that is stealing under the criminal code. The next point is the elements. What are the elements or ingredients of stealing? What are those things the prosecution must prove to sustain the conviction of the accused or defendant for stealing? So as usual, just like with every other offenses, there are usually elements or ingredients that constitute the offense. Ingredients and elements are those things that when they occur, when they are available, when they are present, then a particular offense can be said to be committed. So for stealing, there are some things that when the defendant or the accused do, it can be said to have stolen the thing, and there are those things that the prosecution must prove. The element of stealing have been enumerated in plethora of cases. There are many cases where the court have outlined the element of stealing, such as the case of Oshinye against COP, Ayeni against the state, and etc. And the element as outlined in those cases is that first, the prosecution must prove the ownership of the thing. So number one is ownership of the thing. Number two element is fraudulent taking or conversion. So the prosecution must prove that there was a fraudulent, the taking was fraudulent or the conversion was fraudulent. Then the third element, the prosecution must prove that the thing is capable of being stolen. So that the thing is capable of being stolen, that the thing belongs to another person, that the thing was taken fraudulently or converted from. So these are the three elements. So ownership of the thing stolen, the prosecution must prove. Then fraudulent taking or conversion, then that the thing is capable of being stolen. Well, this element, the second element mentioned, that is fraudulent taking or conversion, some can still decide to split that element into two, split it into taking and conversion. and fraudulent intent. So that element can still be classified as taking or conversion, rather taking or conversion as one element, then fraudulent intent as another element. Still the same thing, because taking is still the same thing as fraudulent taking or conversion. And so if you combine fraudulent taking or conversion, it's still the same thing when you classify it as taking or conversion, or fraudulent or fraudulent taking or conversion is still the same when you classify it as taking or conversion, and then fraudulent intent. Because if the taking is done fraudulently, or the conversion is done fraudulently, then there's fraudulent intent already. You don't need to write again or state again fraudulent intent. So you can put it simply fraudulent taking or conversion, fraudulent, instead of splitting into taking or conversion and then fraudulent intent. Now let's proceed to look at this element. In this video, we are actually going to look at the major element, which is fraudulent taking or conversion. Fraudulent taking or conversion. But before that, the first element is ownership. The prosecution must prove the ownership of the thing stolen. The prosecution must prove that the thing belongs to a particular person. The property stolen belongs to a particular person. It must establish the ownership of the thing. And that is why this is necessary, because in a charge, the charge must be drafted in a way that the ownership, the person who owns the thing, must also be stated in the charge. That you, John, on or about the 25th day of December 2024, stole the property, or stole iPhone, iPhone, the property of Mrs. Onyima. So the person who owns the thing must be stated in the charge, the property of Onyima, that you stole iPhone 7, iPhone 8, iPhone 10, the property of Onyima. So that's why establishing ownership is very important. The next element is fraudulent taking or conversion. So the prosecution must prove that the thing was taken fraudulently, or it was converted fraudulently. Now we can now split these two. Now we can now split this element into two by looking at taking and conversion first, before we proceed to look at when taking or conversion can be said to be fraudulent. That's the fraudulent intent. So taking or conversion is the actus reus, when you take or convert a thing that is capable of being stolen. That's the actus reus of the offense. Then when you do that fraudulently, then the mens rea is when you do it fraudulently, and we shall see when it can be said that taking or conversion was done fraudulently. So first, let's look at taking. What is taking? When can a thing be said to be taken in respect to the offense of stealing? When will you be said to take a thing? When is a thing deemed taken? Literally, taking is when you get something into your hand, when you get something to your hand, or physical possession. You have taken that thing when you get something to your hand, or physical possession. But for stealing, under the criminal code from authority, you may not need to. It is not necessary that you get a thing into your hand completely. Literally, is when you get a thing into your hand completely, you have taken that thing. If you get a thing into your hand completely, for instance, if this book that is here now, it is in my hand now completely, I've taken it. But for the offense of stealing, you need not take it. It is not necessary that you get it into your hand or into your physical possession completely. It is not necessary so. Just try to do a reconnection of learning. If you reconnect what you are learning, just like when we are talking about rape, we say that you don't need to insert the penis completely. You don't need to go into completely into the vagina. The same thing with stealing. In respect of taking, if stealing is by taking, you don't need to take that thing that is capable of being stolen completely before you can be said to take that particular thing. So when can a person be said to take a thing? Well, fortunately, we have the answer to under the criminal code. So section 383 sub 6 tell us or provides stated when a thing can be said to have been taken, when a person can be deemed to take a thing. And let's see what the section say about to take. 383 sub 6 provides a person shall not be deemed to take a thing unless he moves or causes it to move. A person shall not be deemed to take a thing unless he moves or causes it to move. On the other hand, if we now change the statement, it can now state as follows: a person shall be deemed to take a thing if he moves it or causes it to move. If we change the statement to positive, because it's in the negative, a person shall not be deemed until he move or take it, or until he move or causes it to move. That's when. So once, if you just move something, you can be deemed to take that thing. You can be treated or considered as if you have taken that thing once you move it or you cause it to move. So you can see the statutory provision that it is crystal clear and obvious that the thing don't actually need to come into your possession completely, your physical possession. Once you move it or cause it to move, then you can be treated, you can be considered to take, you can be deemed to take that thing. So if my pen is on the table, the same table we are using, you now use your left hand to push it with the intention that I should not be able to find it again, so that later you can take it, or maybe you use your hand to push it down. That is taking. So you cannot be held to complain that, oh, I have not taken it, or I did not take it. If perhaps there was a third eye that was watching you, beholding what you are doing, and I started looking for my pen, and it was revealed that that you move the pen down, or you move it to a particular position, then you cannot complain that, oh, I didn't take it to. You see, I can complain. I can lay a complaint for your charge that you have stolen my pen. So to take, you don't need to. The thing does not need to be in your possession completely. Your physical possession completely. And this rule was aptly and lucidly explained in the case of Arrow against Taylor, in the English case of Arrow against Taylor. That was where the rule was aptly explained by Pickford. Pickford J explained the rule thus: if a man, that's the statement of lordship, if a man put his hand into another man's pocket, seizes is, or okay, if a man put his hand into another man's pocket, seizes his purse, remove it from the position in which it was at the bottom of the pocket to the edge of the pocket, and only provided and is only prevented from taking it entirely out of the pocket by the accident that it meets an obstruction in the shape of the man's belt, it is sufficient as protection to constitute licensee. So licensee is similar, is impari material to the offense of stealing under the criminal code. Licensee is recognized under the English law. And in explaining what constitutes taking for the offense of licensee, his lordship stated that, oh, if somebody has a purse in his pocket and a man puts his hand into the person's pocket and move it from the position it was at the bottom of the pocket, you are now moving it from the bottom where it was, but you were only obstructed because of the position of the person's belt. The person's belt obstructed you, or the nature of the person's trouser obstructed you. That was why you could not move it out. That constitutes taking, is sufficient to establish taking for the offense of licensee under the English law. And it has been agreed and observed that that's what constitutes taking to under the criminal code. So what constitutes taking is the slightest movement or asportation. So the slightest movement or asportation of the thing in question is sufficient to constitute a taking. So that's a taking. Once again, note that for taking to amount to conversion, the person taking it must take it fraudulently. That is the intent. The taking must be fraudulent taking. Because if, for instance, if a person found something on the ground and decided to take the thing in order to examine it well to know the nature of the thing or the owner, then the person cannot be said to steal it if it is just to examine it very well. So such taking is not fraudulent. There's an inquisitive taking. It takes it to inquire into the nature of it or to know, to identify it properly. So for taking to amount to stealing, it must be done fraudulently. And as we shall progress, we shall know when taking is said to be done fraudulently. I shall end this particular video here. Then in the next video, we'll continue with the conversion. We are talking about the two ways in which stealing can be committed: by taking or conversion. Now, I've discussed taking and what constitutes taking. The next one shall be conversion and what constitutes a conversion. Then after that, we now see when taking and conversion can be said to be fraudulent. When can taking and conversion be said to be done fraudulently? That's when it is done with the requisite intent. When taking or conversion is done with the requisite intent, that is when it is fraudulent and can amount to to stealing rather. So thank you. I shall end the discussion here and continue it in another video. See you then.